what is specifically at issue there for journalists is that the law that that the government has cited in certain instances explicitly permits the government to seek the removal of individuals based on their First Amendment protected activity. So in other words, right, the law literally says that you shouldn't try and deport somebody based on their speech or political activities, but you can if the Secretary of State says that your presence would really harm foreign policy interests, which is incredibly vague. The thing that people need to be aware of is there are laws on the books that could conceivably permit the government to try and seek removal of a non-citizen journalist based on their journalism.
Welcome to the East Anchorage Book Club. I'm your host, Andrew Gray. The purpose of this podcast is to tell the stories of Alaskans of interest and importance. Today, our guest is the Vice President of Policy for Reporters Committee for Freedom of the Press, Gabe Rottman. Gabe is a practicing attorney with a focus on the novel issues at the intersection of press freedom, news gathering, and technology. He is the perfect person to discuss the media environment in America today and what resources are available to journalists who, through the course of just doing their jobs, could find themselves in the crosshairs of the government. From 2012 to 2015, Rottman served as the lead federal legislative and regulatory counsel at the American Civil Liberties Union on open government, press freedom, and the First Amendment. While at the ACLU, Rottman directed federal advocacy on the Espionage Act and its implications for journalist source protection. The Reporters Committee for Freedom of the Press was started by journalists in 1970 to provide legal representation to reporters, and that organization remains the leading provider of free legal services to journalists and newsrooms across the U.S. To contact the organization, visit rcfp.org. Gabe Rottman, welcome to the podcast.
Thanks for having me.
Hey, to get started, can you just tell us a little bit about yourself?
Sure. So I actually grew up in Canada. I'm a dual citizen. My mom's from Indiana, but I grew up in Ottawa, Canada. But I was always very interested in U.S. politics, U.S. history. And when I went to university in Canada, I studied basically U.S. history and was always very interested, especially in like civil rights and civil liberties, and especially questions around free speech.
Did you grow up as a dual citizen, or did you apply for dual citizenship later?
I grew up. So my status is citizen by birth, born abroad. So you can elect before you're 18, or at least at the time you could elect before you were 18 to keep both citizenships.
Yeah. Gotcha. I only ask because it seems relevant to our conversation today. Talk about your journey towards Reporters Committee for Freedom of the Press.
Yeah. So, as I ended up around DC, I worked in, political communications for many years, went to law school while I was doing that. I was a litigator in big law for a couple of years, but I always knew that I'd want to go back to public interest and especially this area. And so I was fortunate enough to go back to the ACLU as a legislative counsel. So I worked with Congress and the federal agencies, specifically on First Amendment issues, and a lot of issues at the intersection of free speech, free press, and technology. And so I did that for several years, worked at a couple of other nonprofits, and then the Reporters Committee for Freedom of the Press was looking for an attorney. My role has evolved a little bit into I run our policy shop. So any engagement with Congress, any engagement with the federal agencies, working at a state and local level to pass laws protecting press freedom or to defend against bad laws, I do that work now.
Can you tell us about Reporters Committee for Freedom of the Press, what the organization is, how long it's been around?
Yep. Absolutely. So half a century. We were founded in the early 1970s, when especially the federal government had been going after journalists with subpoenas to try and force them to identify their confidential sources. And there was one particular case. A journalist named Earl Caldwell, who was a reporter for the New York Times and really was kind of a specialist on the Black Panthers. And so he was being subpoenaed by the Nixon Justice Department to try and get him to disclose sensitive information. And that fight was what led to the creation of the Reporters Committee. So, the organization The reason for being was a number of prominent media lawyers and journalists got together and said, we need an organization dedicated to protecting press freedom specifically, and that the Earl Caldwell case, along with two others, were consolidated in a case called Brandsburg at the U.S. Supreme Court, which found that there was no general reporter's privilege. In other words, there was no general legal right for journalists to refuse to answer questions under a criminal grand jury subpoena. But the case has also been interpreted in some courts to provide for a reporter's privilege on a case-by-case basis. So, but basically there was, a number of significant confrontations during the early 1970s between the Nixon administration and the press, and that includes things like the Pentagon Papers as well. And that foment led to the creation of the Reporters Committee.
So I read Murray Fromson's letter on the 35th anniversary of the organization, in which he talked about the founding. And one line that I found really interesting in his letter was when he said that he would go to jail rather than honor a subpoena from any government agency. And I just released a podcast interview with the former editor of the Anchorage Daily News. And one of the things that he said is that he feels disappointed in news organizations, reporters, lacking the courage of their convictions. And I thought about that when I read that line about being willing to go to the jail rather than honor a subpoena. And at least this one former editor in Alaska is saying that he feels like that some of the chutzpah that he saw in years past is lacking today. Can you comment on that?
Well, I'm not sure that I would make the same generalization, but I also have the benefit of being a media lawyer, not a journalist, and therefore I can stick to the law as opposed to, passing judgment. I mean, I think what is notable about that statement, about the statement that you would go to jail, right, is that one of the things that you see throughout the history of the legal debates over press freedom is kind of incredulity on the part of the government that journalists would actually go that far, right? That journalists would rather go to jail than comply with an order to disclose their sources. And it hasn't happened in a long time. There hasn't been, really since Judy Miller and that, there really hasn't been, James Risen is probably the last really big one that went the distance. But on the federal level, there hasn't been that kind of fight over a subpoena trying to force journalists to disclose their sources. And one of the reasons is, nobody really wins in those situations. And there's usually a way to resolve.
Well, I think what I'll approach it a different way, and I'll give you a little bit of information. So the Anchorage Daily News is basically the paper of record for the state of Alaska. And in 2025, their lead reporter for the legislature resigned. Their lead reporter for municipal matters in Anchorage resigned. Their editorial editor, their opinions page editor, resigned. And their editor resigned. And all of them for different reasons. I've had one of them on the podcast. One of them was willing to speak. I would say the overarching thing is that most of them left to go make more money. The lead municipal reporter went to work for the mayor's office. The opinions page editor went to work for the mayor of the Fairbanks North Star Borough as their special assistant, using their skills as a journalist in the partisan political offices where they're getting paid a lot more money and have a better quality of life. And I think that's probably not just an issue in Alaska, but I just think as the decades have gone by, being a journalist is a low-paying job in which, in today's current environment, you're not treated well. Mm-hmm. What's your organization's assessment of the state of journalism today, and what needs to be done to improve the state of journalism today?
Yeah, I mean, so we are a legal services organization, and so the role that we play is making sure that journalists who can't afford them can get lawyers. So we provide, we've never charged for legal services, and actually, if you look at the number of attorneys that we have here, we're one of the largest media law shops in the country, and so certainly, I mean, one of the reasons why, and we've been growing, our docket has been growing, exponentially over the past several years, and a lot of that is due to the fact to the dynamics that you're talking about, right? That the cratering in local news, the general economics around in the industry, and my organization, the Reporters Committee, our mission, our primary mission, is to ensure that journalists can get free legal services when they need them, especially now when there may not be resources to pay for it.
And is the best way for them to get access to your resources through the hotline?
Yes. If you just go to rcfp.org on the web, the hotline's right there. And it's available 24/7. We can also handle emergencies. So journalists getting arrested while covering protests, things like that, we can handle that intake.
And I guess a question I have about in 2025, what qualifies as a journalist? I would say that the media landscape in Alaska, as time has gone by, has been more and more dominated by what people from the legacy news organizations would call bloggers, what the bloggers themselves would call independent journalism.
So when it comes to who qualifies as a journalist, I mean, this is the eternal question, but we take a functional approach. So if you're acting like a journalist, you're a journalist. And certainly when you're talking about whether you should receive legal protections under the First Amendment or under a state shield law, if your function, if what you are doing is journalistic, then you should receive those legal protections as a journalist, right? And the reason for that is because if judges or other government officials start getting in the business of deciding who's a journalist and who's not, that looks a lot like a licensing scheme. And the whole origin of the First Amendment is that in the United States, we don't let the government license the press.
So I read your article that was released today in The Nuance, which is your organization's monthly newsletter. The title was Why Journalists Should Care About Military Involvement in Domestic Law Enforcement. I guess like the context is in Los Angeles when Donald Trump deployed the National Guard to quell protests there. Journalists who were covering the protests are suddenly being surrounded by folks in military uniforms. Can you talk a little bit about why journalists should care about military involvement in domestic law enforcement?
Yeah, and we were getting a lot of questions about this. There's also been kind of militarization at the southern border, which journalists who are covering immigration issues have been asking about. And the bottom line is that the journalists should care about and we're talking specifically about the use of the military for civilian law enforcement. Folks in military uniforms being on the scene with DHS, ICE personnel, and so for journalists, I mean, the short answer is they should care for the same reason that the general public should care, is that, in the United States, we have, going back to the formation of the Bill of Rights. I mean, the Third Amendment in the Bill of Rights says you can't quarter soldiers in your house, right? And one of the reasons is because our political system is based on the insight that having a large standing army deployed domestically can be a problem for civil liberties. And so, what we've seen in LA is actually not using the military for civilian law enforcement. They've kind of come up to the edge of doing that. But right now, the National Guard troops and the active duty troops who are deployed are there to protect ICE personnel and federal property. But if you were to see, for instance, the president invoke the Insurrection Act, which would permit the use of troops for civilian law enforcement, that could be of significant concern. And the other practical reason for that is, one thing that my organization, the Reporters Committee, does is we engage with both newsrooms and police departments to train both groups on how to best interact, especially when you're covering protests. And one thing that we've seen with that work is that on a local level, there tend to be connections between the police department and the local news outlets that you just wouldn't get with National Guard troops who are deployed from elsewhere, or active duty troops who are deployed from elsewhere. And that can cause negative interactions between press and police, especially when you're talking about something like a mass demonstration or a protest. So we were hoping to flesh out a little bit of the law there, and also just make the point that journalists should be thinking about these issues.
Right. Well, part of the article that was interesting to me, you wrote that journalists don't really have any special rights in terms of they're allowed to be wherever the public is allowed to be. But where it gets kind of complicated is in like dispersing a mob or something like that, that the journalist is not necessarily part of that mob. I don't know. Like, can you do the legal distinction?
So this is actually an emerging area of law for various reasons. There aren't a lot of cases on this specific question, but so the question is whether, if law enforcement has a valid dispersal order, right? You've got a crowd, people are starting to throw bottles, whatever. Law enforcement's got a valid dispersal order. Do journalists who are covering the protest and the law enforcement response to the protest have a legal right to remain on the scene? The short answer is there are no special rights for journalists. Journalists have the right to be where the public can be, and the public has a right to be where the press can be. But the nuance is that the First Amendment itself requires that the law enforcement response to unlawful activity be tailored to address that unlawful activity. And so if you've got a journalist who's standing off to the side, not obstructing police, covering the protest response, then it may just be not properly tailored under the First Amendment to disperse the journalists alongside the crowd. And the courts that have looked at that question tend to agree with that analysis. But again, there isn't a lot of law on it, right? There is the area of whether there's a right to record police activity in public. And every court that has looked at that has said there is, but the U.S. Supreme Court has not decisively answered that question. But then there's this other area where it just, can the journalist kind of remain on the scene? But it's a very, very interesting legal question, but it has huge concrete implications for journalists because when journalists are detained, arrested, or subjected to the use of force, it's usually in the context of covering a protest.
You wrote that this is the most dangerous situation that journalists find themselves in is when they're covering protests. I guess because they can be confused for a protester. They can, they run the risk of having violence directed towards them by protesters or by law enforcement, or in this case by the military, that it is their most dangerous moment.
Yeah, that's right. That's right. I mean, it's, just the chaotic nature of it. And, it's the most dangerous, when you actually look at the numbers of journalists who, most journalist arrests are, covering protest activity. And so, it can be, you've got a large crowd, things get chaotic, the crowd moves in various directions, journalists get mixed up among the protesters and then arrested. That happens, and absolutely, there's also instances where, journalists are targeted by the crowd itself, or potentially by law enforcement, which is a clear First Amendment violation.
We had a situation in Alaska where we do not have a federal ICE detention facility in Alaska, but the Washington facility in Tacoma was full. And so they actually sent 40 detainees to Alaska to be held in our prison. And we held, I'm the chair of the House Judiciary Committee. We held a hearing on it. And basically in preparation for the hearing, I reviewed the detention guidelines and what detainees are entitled to. And in those guidelines is access to reporters. Reporters have access to the detainees. What was interesting is that the reporters who had tried to get access to the detainees, the response, and this was relayed to me by a reporter, was that the Department of Corrections has said that they were overwhelmed and that they didn't have capacity to facilitate the media meeting with any detainees. Is that an acceptable response?
I don't know about the specific instance, but certainly lack of capacity or lack of resources, shouldn't be the answer. We've encountered arguments like that in other contexts, like FOIA or something like that. And the law is the law, and if the law applies, then the government needs to be funding itself in order to comply with the law.
I guess going off of that, I looked at the previous newsletter article that was written by Allison Vale and Ellen Goodrich from June of 2025. The title was Immigration Crackdown Reveals Grave Threats to Press Freedom. In this article, you guys were talking about the detainment of the students at Columbia and at Tufts, and how basically detaining people for their political views runs the risk of the same thing happening to reporters. And you actually had an example from 1986 about a Colombian journalist, Patricia Lara, who was detained and her visa revoked when she was trying to come to attend an award ceremony at Columbia University. I don't know. Can you talk about some of the fears that people have around the way ICE is detaining people without due process, and the fears that journalists specifically would have?
With respect to these questions, the immigration enforcement and seeking the removal of these students that we were writing about. So what is specifically an issue there for journalists is that the law that the government has cited in certain instances explicitly permits the government to seek the removal of individuals based on their First Amendment protected activity. So in other words, right, the law literally says that you shouldn't try and deport somebody based on their speech or political activities, but you can if the Secretary of State says that your presence would really harm foreign policy interests, which is incredibly vague. And so what we've been pointing to there is that, again, because these laws have been very rarely used, there's not a lot of law on them. Like there's not a lot of cases out there on them. But the thing that people need to be aware of is there are laws on the books that could conceivably permit the government to try and seek removal of a non-citizen journalist based on their journalism, right? Because the government perceives that reportage as unfavorable or embarrassing, and that's why we're tracking the Oster case and the Khalil case, the ones that we wrote about before. So it as with all things, right? When you're talking about freedom of speech, one aspect of freedom of speech is freedom of the press. And so things that are potentially corrosive to freedom of speech can also be corrosive to freedom of the press.
Do you guys keep tracks of trends in terms of how many calls you're getting versus the types of requests that you're getting from journalists across the country? And have those changed much recently?
Certainly in terms of volume, right, and I think that's probably due to many different factors, and like we were just talking about, there's just an incredibly increasing need for pro bono legal services for journalists. So there's definitely been an uptick. I'm not sure about trends and things that we've been seeing. At a state level, this is actually a positive story. But at the state level, there's been, for instance, passage of pretty strong anti-SLAPP laws. These are laws that provide a mechanism to quickly dismiss cases that are not really brought to win; they're brought to intimidate or harass the defendant. And so we've actually seen states, across the country passing these laws, which is a positive trend.
Well, you had worked on the Press Act, all capital letters, which was passed through the U.S. House unanimously.
Yep.
And made its way over to the Senate. And essentially, it was to provide another layer of protection of journalists in our country. I think, maybe not directly out of fear for a second Trump administration, but at least from my reading, because there was some fear that if President Trump were elected again, that there might be more intimidation of the press. And I read an article on the Freedom of the Press Foundation's website, basically just eviscerating the Senate for not passing it. Can you comment about the need for that act and any disappointment that you guys have that it did not pass the Senate when it could, and when there was a president who would have signed it?
It was terribly disappointing that it didn't move, and I think one of the reasons that it was terribly disappointing is that, aside from the discourse around it became pretty politicized, right? To the point where you had President Trump, tweeting about how the bill needed to fail. And the thing about the Press Act is that, you just mentioned that the House, so not just once, but twice, the two consecutive Congresses now, the Press Act has passed the House of Representatives unanimously without objection, right? It has incredibly strong bipartisan support, and has had incredibly strong bipartisan support going back to the 2000s when one of the main co-sponsors was former Vice President Mike Pence. And the reason for that is that, the Press Act, and so just to back up, the Press Act would be a federal reporter shield law. It would right now, virtually every state, 41 states actually have a statute on the books. They have a law on the books that provides journalists some protections from having to identify confidential sources or disclose sensitive news gathering material. And the other states that don't have a law on the books, the courts have recognized some protections. There isn't a federal law right now, and the Press Act would be that law. And and so, as I was saying, everybody knows, right, that the Press Act is fundamentally apolitical, right? Free press means means vigorous vigorous adversarial press, at all points on the ideological spectrum. And so, if you look at the defamation cases that were brought after the election against Fox and Newsmax, if you look at the debate over or the case where a journalist, Catherine Herridge, is currently fighting not to have to identify her confidential sources in federal court in DC in a case where she's not even a party. One of the most disappointing things I think about the Press Act last Congress is that it became politicized when in fact it is fundamentally a bipartisan, apolitical measure.
Right. And I guess one of the sponsors in the Senate was Mike Lee of Utah, who's extraordinarily conservative. So it seems like, that says a lot. Just for the record, Alaska does have a shield law from 1967. I'm looking at your website and it's reporting on it. And it basically says that there's not really been any significant litigation regarding the shield law, and it hasn't had any amendments or changes to it since 1967. Basically, a public official or reporter may not be compelled to disclose the source of information procured or obtained while acting in the course of duties as a public official or reporter.
Okay.
Yeah. So that would be a pretty standard one.
Pretty standard. Yep. Yeah. The difference between them is, the amount of protection that they'll give. Like, so for instance, some of them will provide absolute protections in criminal cases. That there's no case where a journalist can be compelled to testify. And then some of them have what's called the qualified privilege, where if you've got a good enough reason, you can override the law.
Gotcha. You're a legal organization. A lot of your work is on providing pro bono work. What are there other resources that you guys offer?
Well, we've got a whole bunch of guides that are available on our website, again, rcfp.org. We've got guides. We were just talking about reporter shield statutes. We have the Reporter's Privilege Guide, which is the most comprehensive compendium on those laws. We have a number of other guides. We have a guide on, for instance, how to cover protests safely. What are your legal rights covering protests? We just recently put out a guide on reporting on immigration issues. So things like court access questions, and how to navigate public records requests on immigration issues. We have and we have a number of others. In terms of the other resources that we provide, I mean, all of the legal services, where we tend to do a lot of public records cases. So we have a whole team here that specializes in the Freedom of Information Act, the Federal Freedom of Information Act.
I wanted to talk a little bit about that because I was basically a community activist before I ran for office, and that was something that was a really big problem for just everyday citizens in terms of not basically getting any sort of documentation from our municipal government in Anchorage. There was a huge delay in getting records, and B, sometimes they would do what I would view, and I mean, for people listening, I'm talking about the previous mayoral administration. I can't speak to the current one, but of overcharging, of basically saying that it was going to take one employee 16 hours to put together these records, and you're gonna have to pay $100 an hour or something. So you would get it's like, do you want to proceed with this request? We're going to charge you $800, and that's a lot for a citizen who is just concerned about the approval of a homeless shelter at a certain corner. It just seemed like they were manipulating their guidelines in such a way as to make it impossible for an everyday person to request records. Is that something that's unique to Anchorage, or do you guys see that in other places?
No, I mean, it's not a universal problem. A lot of government agencies, take their obligations under the state or local transparency laws, take them very seriously. That kind of gamesmanship does happen, and we've certainly engaged when on issues of excessive fees. One thing that we've also in New Jersey, for instance, there was a push to change the ways that you get fees in public records cases. So if you win in public records cases, you can get your attorney's fees back. And it may seem like a small thing or kind of a boring detail, but something like that is crucially important in making sure that the requester can find legal help if they need to actually go to court in order to enforce the request. We've definitely seen issues like that and advocated to provide for stronger protections to make sure that stuff doesn't happen.
Well, it becomes relevant to a question that we had earlier about who is a reporter. There was a study by Medill at Northwestern University that basically showed that over half of U.S. counties lack a local newspaper. Yep. And then it was a combination study between George Mason University and Tulane University that showed that news deserts, places without local news coverage, that there's a 6.9% increase in corruption of local governments. When there's no reporter covering the local government, then the chances for corruption are higher. And one thing that they point out in that study is that's just cases of corruption that went to trial. You don't know what you don't know. So likely the number is much higher. And I guess this is a case where having local reporters is essential to maintaining the law-abiding aspect of your local government. If there's no one there to watch, then there's no reason to follow the statutes. And in cases like this, where you have local citizens doing records requests and not getting them, obviously your organization can't help everybody on these things, but what's your advice? Should if somebody thinks that they might make the case that they're a reporter in this case, should they reach out to your organization?
Well, I mean, so certainly if you're talking about individuals who are recognizing that there is a news desert in their community and they're trying to fill that, and you're concerned about your legal rights, then absolutely reach out. We do have a policy. Our services are for journalists. But again, we take a functional approach to who's a journalist. So, if you're engaged in collecting information with the intent to disseminate that information to the public in the public interest, then that's journalistic activity.
I listened to On the Media from a few weeks ago, and they interviewed the author of the Project 2025 paper justifying denying any government funding towards public media, which we just saw. They're rescinding action on that. They're pulling the funding back. And he basically was making the case, and they were talking about Alaska specifically. So a specific problem in Alaska is that we're a very, very rural state with lots of areas that don't have good, reliable internet. The only thing that they can rely on is the local radio station in the case of an emergency.
Yep.
And what he was making the point is like, well, it's supply and demand. If there is a demand in that rural community for a local radio station that provides it, then the local government or the state government should be the folks who decide that that's needed and should fund it, not the federal government. We are in a financial crisis and we've had to massively slash our state government. So the idea that we could fill in the gaps for everything that the federal government is clawing back is just not realistic. And when we're talking about rural Alaska, these are extraordinarily impoverished communities that already are suffering, like they cannot do this. I'm not sure where my question is. You know what? I'll apply it to everything that's happened in the last week. The firing of Stephen Colbert, or I guess the canceling of his late night show because he criticized the $16 million, what he considered a bribe to the Trump administration from CBS for a case that they would probably have won, about the editing of the Kamala Harris interview on 60 Minutes, the defunding of NPR and PBS, the
CBS settlement. So there was the
the CBS settlement, and then also it's not quite as recent, but the executive producer of 60 Minutes resigning because he felt he no longer had independent authority of his own show. I think we're just seeing an environment in which it appears that the Trump administration is winning in terms of intimidating news organizations into having less antagonistic coverage.
So that's certainly the concern. But what I will say that is a through line with the rescission of NPR of money for NPR and PBS, all of the stuff that's going on connected to the Vice President Harris's interview on 60 Minutes that led to the lawsuit against 60 Minutes, that's led to an inquiry at the Federal Communications Commission into whether CBS distorted the news, quote unquote. So the through line in all of those cases is they involve the use of governmental power in some way in order to target and combat perceived bias. And that's the biggest concern. There's this concept in First Amendment law called viewpoint discrimination, right? There's where the most dangerous thing to democracy when it comes to the First Amendment and free speech is if the government is able to pick and choose sides in public debate, to engage in viewpoint discrimination. And a lot of the things that you've seen with all of these cases under the second Trump administration, they look like viewpoint discrimination. And in some cases, like the AP access case where the White House was denying AP access to the press pool because they made the editorial choice to continue to refer to the Gulf of Mexico as the Gulf of Mexico while acknowledging that the president changed the name to Gulf of America, right? That was explicitly viewpoint discriminatory, right? The government was saying, we are retaliating against you because we don't like your editorial choice. And that is the thing that I think media lawyers, that's where our hair is on fire. That is one of the most acute threats to one of the most acute threats to democracy, and to civil liberties, right, is the idea that the government could try and put its thumb on the scale of public debate to its own benefit.
With the Supreme Court balanced the way it is and ruling the way it's ruling, I mean, is there any doubt that maybe these cases that seem so cut and dry that the journalist is in the right could have the ruling against them just because you have partisan judges who might rule against them? I don't know, because because they don't like journalists. Like, I mean, I think that's a fear, is that maybe the courts aren't going to be the safe haven that we've hoped them to be in terms of protecting journalists in their role.
Yeah, so I guess there's probably two answers to that, right? I mean, absolutely, there's been some academic research on how the courts perceive the press and how that changes over time. You know, you've got sort of the post-Watergate glow, right, where the press was really seen as a
savior of democracy.
Exactly. And then you've got, the various indicators of trust in media, et cetera, now, which are less. People do still trust local news, though, which is, kind of a key data point. All of that said, when you're talking about First Amendment protections for the press, things like the New York Times v. Sullivan U.S. Supreme Court case, right, which basically says that if you're a public figure and you want to sue, it says that if you're a public official, which was then extended to public figure, but it basically says if you're a powerful person and you want to sue a journalist for defamation, you've got to have a safety valve built in for honest mistakes by the press, because it's such a hurly-burly profession where, journalists, their whole job is to get things right, to get things as accurate as they possibly can. But sometimes honest mistakes happen, and you have to have a safety valve built in for those honest mistakes. And that is the public figure who's suing the journalist needs to show that the journalist really had a sense that this was false.
That was the Sarah Palin case.
So Sarah Palin has that issue, as baked in. Yeah, the question there is whether the term media lawyers hate the term because it means nothing. It's like, the Holy Roman Empire, but the term is actual malice, and in actual malice just means that the public figure needs to prove that the journalist really harbored serious doubts about the accuracy of the reporting. But the point that I was getting to is that that rule, the actual malice rule in New York Times v. Sullivan, there's some concern that this Supreme Court could revisit it and change it. But at the end of the day, that rule protects everybody. And so, for instance, in Florida, the Florida legislature has proposed laws that would tee up a constitutional challenge or tee up a revisitation to those the rule in Sullivan, and it was defeated by a bipartisan coalition of news organizations, because everybody at all points on the ideological spectrum realizes that in order for public discourse to be free, everybody needs to be protected.
Well, Gabe Rottman, thanks so much for being on the show today. A last question that we just ask folks is if they have a book they want to recommend. But in your case, I don't know if there's if people are interested in this issue, if there's any other form of media that you recommend other than your website, which I have to say has a lot of material on it.
So this shameless plug for our various newsletters, including The Nuance, which is the newsletter that we put out every month. And you could subscribe on rcfp.org. And then I'll recommend a book, actually, Make No Law by Anthony Lewis, which is a popular legal history of the Sullivan case. And, I think really lays out these issues in a very compelling, easy to read way.
Well, hey, thanks again. Thanks so much for being on the show today.
Thank you. Thanks so much.
I'm including a link to the Reporters Committee for Freedom of the Press in the show notes. And you'll find at that link the article published this week by Gabe Rottman, Why Journalists Should Care About Military Involvement in Domestic Law Enforcement. Thank you, listeners. If you like what you heard, please subscribe, rate, and review us. To contact me, email rep.andrew.gray@aklive.gov or call 907-269-0123.